And without further ado, I'd like to present our first speaker, attorney Anjel Burgess, who will be presenting Narcolepsy and Disability, What to Do When the Writing's on the Wall. Attorney Anjel Burgess has devoted her practice to helping individuals and families to navigate through the Social Security disability practice. Her clients consist of both children and adults who are located throughout the country and have conditions that affect their ability to perform full-time work or engage in school-related activities. Attorney Burgess has been featured as a speaker on disability issues for a number of organizations, including the Hypersomnia Foundation, the National Alliance on Mental Illness, the Lupus Foundation of America, and the Cobb County Bar Association. And with that, please help me welcome Ms. Anjel Burgess.
Good afternoon. My name is Anjel Burgess, and I am a Social Security disability attorney. My goal today in presenting this information to you is to provide you with the tools that you need to prepare in the event that the symptoms from narcolepsy interfere with your ability to work successfully. Now, ideally, if you're having difficulties performing your job due to your symptoms, at this point you will have talked with your supervisor or someone in human resources to develop a plan which would include some accommodations that you can explore to help make your work successful. In the event that accommodations are insufficient for you to be able to work successfully, then there are 3 types of disability insurance that you want to become very familiar with: short-term disability, long-term disability, and Social Security disability. Short-term disability most often is an employer-sponsored plan. So what that means is that typically you will have the option of either contributing to premiums for short-term disability through payroll, or your employer may offer the short-term disability benefits as an added benefit. Short-term disability benefits are designed to replace a portion of your paycheck for a short period of time, which can be anywhere from 3 to 6 months. The idea behind short-term disability is that you are not able to work for a short period of time, that your doctor has recommended that you go out of work so that you can seek the necessary medical treatment and hopefully be able to return to the workforce. Should your symptoms not improve after a period of short-term disability, you will want to make sure that you have long-term disability options available to you as well. Long-term disability options may be available as part of an employer-sponsored program, but you can also purchase long-term disability benefits privately. A good place to start would be the insurance company that provides you with auto or home insurance. And there are also other companies such as Aflac that will sell individual long-term disability policies. Now, what it means to receive benefits under a long-term disability policy is that the conditions or your symptoms are keeping you out of work for a period of time which exceeds the available short-term disability benefits. Each policy has a differing definition of disability and the terms may vary, but generally speaking, there are 2 types of long-term disability policies. One is an own occupation policy, and what that means is that your symptoms prevent you from performing the job duties of the occupation that you had currently been involved in. The other is an any occupation policy, which means that your symptoms are severe enough that they would keep you from working in any job. Now, many policies will adopt what's considered to be a hybrid of the 2 types of policies. For example, they may have an own occupation element for up to 2 years. And then after 2 years of being out of work, then the policy allows the definition to shift to an any occupation standard. So it's completely feasible that an individual may receive long-term disability benefits for a short period of time, as in 9 to 12 months. But it's also possible that those benefits could extend all the way through retirement age, depending on the policy. Now, in contrast to short-term and long-term disability, we have Social Security disability. And there's a very confusing definition of what it means to be disabled from the Social Security Administration. But to simplify things significantly, to be disabled means that you are unable, due to physical and or mental conditions, to perform any full-time competitive employment for a period that is expected to last, has lasted for at least a year, or that condition could be one that results in death. Now, there is often great confusion about the differences between long-term disability and Social Security disability. And I've illustrated those differences here on the next couple of slides. For long-term disability, the policy terms are going to vary from one policy to the next, whereas Social Security has a universal set of rules. It does not vary because you live in Georgia as opposed to living in Massachusetts. The definition of disability and the rules are the same. It is a federal program. In order to be eligible for long-term disability benefits, your eligibility could be through an employer-sponsored policy, or it could be through a private policy that you purchase on your own. The entitlement to Social Security disability benefits, on the other hand, is based upon either your contribution to the program through the payment of FICA taxes in your paycheck, through self-employment taxes, or sometimes you can be eligible for Social Security disability based purely on financial need. So you may not have contributed anything to the system, but because you are in a position of financial need, you can be eligible to receive those benefits. Now, for long-term disability, there is typically a waiting period. It could be 90 days, it could be 120, it could be 180 days. It just depends on the policy. For Social Security disability, there are two programs. One is the Disability Insurance Benefits Program, which is also known as DIB, and you pay into DIB benefits through the payment of FICA taxes. In order to receive the DIB benefits, there is a waiting period of 5 months. But if you are eligible for the financial-based program, which is called SSI, or Supplemental Security Income, then there is no waiting period in order to receive those benefits. For long-term disability policies, typically the maximum duration of benefits can vary from one policy to the next, but it could be up to retirement age. Now, this is similar to Social Security disability, where if your disability continues, you could be eligible to receive those benefits up through retirement age as well. Long-term disability policies may have some pre-existing condition rules that could exclude you from coverage, whereas Social Security disability says it doesn't matter. If you have pre-existing conditions, we are going to consider you as a whole person, and we are going to look at all of your conditions and how they impact your ability to function. In order to prove a claim for long-term disability, you may need to have a physician who provides written statements, stating that you're not able to work in order to receive those benefits. With Social Security disability, you are not required to have any written proof of disability from a physician in order to file a claim. For both programs, the process is very much a medical records review process. So the reviewers or examiners want to see what your medical records are saying about your symptoms, your response to treatment, the severity of those symptoms, and how they're impacting your functioning. As I stated previously, long-term disability policies may exclude some conditions, whereas Social Security disability does not exclude any condition. The benefit amount that you're entitled to for long-term disability is determined by how much money you made at that particular job that you were working in when you went out on long-term disability. Whereas Social Security disability, the benefit amount is going to vary based on your lifetime earnings. An average of your lifetime earnings determines how much your DIB benefit may be. And SSI benefit amounts are set. They have a set maximum of benefit that you can receive if you qualify for that program based on financial need. With long-term disability benefits, most policies require that if you are going to receive long-term disability benefits, you must also apply for Social Security disability benefits. And the rationale behind that is that most long-term disability policies will have a provision in them that states that they can reduce your payment by any amount of Social Security disability benefits that you either receive or that you would be entitled to receive. So in most cases, if you need to apply for long-term disability, you should expect that you will also be required to apply for and go through the process to try to get Social Security disability benefits. So the long-term disability benefits can be offset, and I just gave an example of that, by Social Security disability benefits. Long-term disability benefits are available to workers. So you are the person that worked that has to go out of work because of your conditions, and you are the only person that's entitled to receive the long-term disability benefits. Social Security disability benefits, on the other hand, can be available to the person who has actually worked and paid into the system. It can be available to adults who have never worked, and the benefits can also be available to children. So as long as you meet the definition of disability from a Social Security standpoint, you may be entitled to receive benefits. Now, what is the process for Social Security, you may ask? Well, generally speaking, it can be a long process. For most people that apply for benefits and ultimately receive them, it can be a three-step process. The first step is to file the initial application, where you have approximately a 1/4 to 1/3% chance of being approved at the initial level. And depending on where you live, some states process the claims at a faster rate than others. It can take anywhere from 3 to 8 months to get a decision on that initial application. The second step, if you've been denied disability at that initial level, is to file for what's called reconsideration, which is essentially asking Social Security, please take another look at my application and my evidence and make a fresh decision in my case. At the reconsideration level, the chances of getting approved are much lower. Unfortunately, they range anywhere from 7 to 10% approval at the reconsideration level. And as far as the timeline is concerned, it can take anywhere from 1 to 6 months after you have filed for reconsideration to receive a decision. If you are denied at the reconsideration level, then you will move on to the next step in the process, which is to request a hearing in front of an administrative law judge. This is the stage in the process where the vast majority of people are approved for Social Security benefits. So you get the opportunity to appear live, by video, or these days over the telephone, in front of an administrative law judge to present your case. And roughly 65% of individuals that do get approved will get approved after going all the way through the process to the hearing level. Now, if you need to file for Social Security disability, it's important to know that, number one, Social Security does recognize narcolepsy as a condition, which is great news. And they have some specific guidance on narcolepsy, which states that it is a chronic neurological disorder that's characterized by the recurrent periods of an irresistible urge to sleep, accompanied by 3 accessory events. One would be cataplexy. The second accessory event are hypnagogic hallucinations. And the third accessory event is sleep paralysis. Now, Social Security discusses signs and symptoms of narcolepsy that can be helpful if you need to file a claim. They acknowledge that there are no physical abnormalities in narcolepsy, and that with the exception of sleep studies, laboratory studies could be perfectly normal. Social Security acknowledges that sleep symptoms can range from being mild drowsiness to such severe sleepiness that an individual may spend their day basically going in and out of sleep, may be unable to work, unable to supervise their home or engage in any play. The sleep periods, as is defined by Social Security, could range from a few seconds to 30 minutes, and certainly could be even longer than that. The most important thing for you to know is that Social Security does recognize that not all individuals with narcolepsy will have all of the symptoms, that it's very much a disease that impacts people in different ways, and that the most important thing to do is to make sure that you can prove how it impacts you. Now, Social Security does recognize that cataplexy is observed in the vast majority of cases, and even states that, you know, if there is adequate documentation of cataplexy, that this could be sufficient to acknowledge or establish that narcolepsy is a severe impairment without having any sleep studies. So once the diagnosis of narcolepsy has been established, once symptoms have been documented, then there is a need to determine the severity of narcolepsy, because it can vary from one person to the next. Social Security is clear in that the severity should not be evaluated until at least 3 months of prescribed treatment have been received. So if you are newly diagnosed, it's important to figure out how treatment is going to impact your symptoms. And it's most helpful if the time has passed and it's been at least 3 months before you are alleging that your symptoms are not adequately controlled. It is not necessary for you to obtain an EEG to prove that you have narcolepsy or to prove the severity of the narcolepsy. The Social Security Administration also acknowledges that stimulants and mood elevators may be helpful in the treatment of narcolepsy, but there are no blood tests that can universally be taken that will establish the severity of either the narcolepsy or any correlation between the presence of the medication in the system and its efficacy. Finally, Social Security does state that in order to determine the severity of narcolepsy, it is important. And I would actually scratch out important if I could, and I would replace that with necessary to obtain from an ongoing treatment source. So from your treating physician, you want to be sure to get a description of the medications that you're taking, how you're responding to the medications, what your episodes or what the sleep attacks, what do they look like? Describe them, describe what happens, so that Social Security can get a better understanding of how they impact your functioning. And then any other events, cataplexy, the hypnagogic hallucinations, or sleep paralysis. You want to make sure that in the notes there's a description of not only the fact that these things happen, but what takes place when there is an episode of cataplexy. Do you usually fall to the ground? Can you feel yourself starting to fall when you have an episode of cataplexy? How is the sleep paralysis? How long does it take you to kind of get out of an episode of sleep paralysis? And what are the symptoms that you're experiencing during such episodes? So as you can see, treatment is critical in proving that the narcolepsy is severe and in proving that it prevents you from working. Some helpful tips for treatment is start a journal. Try to keep a record of your nap frequency, how long the naps are lasting. Are they refreshing naps? Is there anything that precipitates a nap? Such as I noticed that when I wash dishes, I have to take a nap immediately thereafter, that I'm easily fatigued. Those sorts of things can be helpful to show your physician when you go for your doctor's visit, so that they get a good idea of how effective the treatment is. It's very important that you find a doctor that you can trust, that you feel listens to you, and is trying to help you get to a place where you can resume some sense of normalcy in your life. You also want to be very vocal about your symptoms. Gone are the days where you should go to the doctor, and when the doctor asks you how you're doing, you say, "I'm fine," when you're really not. You need to explain to the doctor what your symptoms are, how the treatment is working for you, if at all, and try to explore some other alternatives to treatment. And you should be very open to that. Things such as scheduled naps or trying different treatment, different medication. Those are the types of things that you want to try in order to see if there's anything that will help you to manage the symptoms. Also, asking for help, whether that's in the home, whether that's on the job, is critical so that you can focus on trying to manage your symptoms and be as effective as you can in just everyday life. A support group can also be extremely helpful because members of a support group not only can identify with the symptoms that you are experiencing, but have typically tried different treatments, have seen good doctors that they can recommend, and just give you some general guidance on how to make daily life a little easier for you. Now, let's say you've been going to the doctor, you're taking your medications, you're doing everything that you need to do in order to establish a claim for disability. How do you prove it? You've got the records. It's important to know that the records are the most important thing. So you're going to need documented support for the diagnosis of narcolepsy, things that can be helpful. Certainly medical records are the best. If there are any sleep studies that your doctor has used to confirm the diagnosis of narcolepsy, then that information is helpful. If your doctor has ruled out other conditions as a possible cause for your symptoms, it's helpful to know that as well in establishing the diagnosis. Also, again, making sure that you are reporting or documenting any side effects from medications, any issues that you have with the efficacy of the medications or the treatment that has been recommended. And finally, any letters that the doctor will write explaining your condition, your symptoms, your response to treatment, or forms or statements can be helpful in proving a disability claim. Also, you'll want to be mindful that not only do you have to prove that you have a severe condition, that the narcolepsy is interfering with your daily activities, it's kept you from doing the job that you were doing, you also need to be able to prove that it's keeping you from working, period. And ways that you can do that are a bit unconventional, but can be very effective, such as employment records. If you have performance evaluations and it's been documented that over the years your performance has declined, that you're making more mistakes, if you are having problems with attendance, if you are finding that you can't get to work on time, or that you are taking longer breaks than usual because you had to go into the bathroom to take a nap, or you had to go to your car to take a nap, and your supervisor is looking for you and frequently unable to find you, that can be good evidence of your inability to work successfully. If you've had any disciplinary warnings, whether that's an email that your supervisor sent to you and said, hey, we're trying to work with you, but I've noticed you sleeping a lot on the job. Any of those things can be helpful in proving that you're unable to work. And also, if you receive a separation notice, sometimes the separation notices will say things like, unable to return to work from a medical absence, or, unable to perform the duties of the job. And that can be helpful in establishing that it is the symptoms from the narcolepsy that's preventing you from doing so. Also, if there are any vocational rehabilitation records, such as work readiness assessments, where you've actually done work in an environment for the purpose of being evaluated to see how competitive you can be in the workforce, that can be helpful. If there are any school records, such as an IEP, 504 plans, teacher evaluations, or disciplinary reports, those can also be helpful in proving a disability claim. Most importantly, it is vital that you stay encouraged. that you use these tips, hopefully to plan, and you're in a position where you're able to, hold on to your job, and you can plan for things just in case they don't work out as you'd like them to, so that you don't experience any interruptions to your income, so that you don't lose your health insurance, and that you're able to just utilize short-term disability, long-term disability, and Social Security disability to help you to, continue to access the treatment that you need, get your medication, and live a good life. If you have any questions, I am available to answer them at this time for the question and answer portion of this presentation. And I thank you very much for tuning in. Hello. So the first question that I have here asks whether compensation from clinical trials from pharmaceutical companies will interfere with disability benefits. And the answer to that is no. Any compensation that you receive that is not the direct product of actual work that you're performing, you will just need to have some documentation which shows that. So any letters that you may have, any check stubs that you may have that would indicate that this is for participation in the clinical trial, you will just need to be able to provide that information to the Social Security Administration so that they know that this is not the result of actual work activity. A similar question is, how different are these considerations if you own your own business? You may not be able to work, but if someone else is running the business, would you be eligible? And does receiving a distribution of profits remove your eligibility? If you own your own business, documentation will be even more important. Social Security gets wage information from the IRS. So it depends on what and how that information is reported to the IRS. If you are reporting any sort of profits from your business, you'll need to be able to explain, to document that these are profits, for example, from real estate commissions. And you may be able to provide letters or reports that show that the income was from the commissions, and you'll have to explain that this is for X amount of hours of work that I performed over this period of time. The idea is to make sure that you are able to explain to Social Security that the earnings are not a direct result of your active involvement. And if it is a result of your active involvement, you'll need to be able to explain what level of involvement you have. If someone else is running the business for you, then yes, you may still be eligible, but again, you are going to have to prove that the earnings are not from your direct involvement or your direct and active participation in the job. And that could include statements from your employees or statements from your tax preparer that say, okay, these earnings are a direct result of X. You could provide an affidavit that shows that you are not the actual person who was performing the job, that you have employees, that you have X number of employees, and that you take your share of profit. So it is entirely possible to be a business owner who is receiving income, but again, not from direct work activity. You just have to be able to prove that. The next question is, when going through any of the disability processes, is it recommended to get recommendation? And my answer is yes. This process, whether it's for Social Security disability primarily, I would say from the outset, it is to your benefit to get representation. You want to be able to consult with someone who knows the process, who knows what Social Security is looking for when they're asking you specific questions, when they're having you to fill out forms. So it's more helpful to have someone involved in the outset to help you establish your claim. Now, with that being said, as far as Social Security disability is concerned, you can hire an attorney at any stage of the process to help you. So for people who prefer to apply on their own, they can do that. It's perfectly acceptable to apply on your own and see what Social Security decides. And if you receive a denial, then at that point you may want to seek some representation to help you move through the process. The idea is to make sure that you are not filing anything or making any statements that are detrimental to you in the future because you weren't aware of how the process worked. And you also want to make sure that you filed the right type of claim and that you understand the difference between the Social Security Disability Insurance Benefits Program and SSI. As far as short and long-term disability are concerned, most people will apply directly, through their employer, and most do not seek representation unless there has been a denial. But certainly, if you have been denied short-term or long-term disability benefits, you want to immediately seek a consultation with an attorney to assist you going forward in that process. The next question is, can a person with narcolepsy qualify for state disability while pregnant and unable to take their meds? Now, with this question, I'm assuming that perhaps prior to becoming pregnant, you may have been able to perform the duties of your job, but having to come off of your medication has prevented you from doing so. If that is in fact the case, then what you will want to pursue is short-term disability if it's available, and potentially long-term disability. But Social Security disability is not going to be a good option for you because with Social Security disability, the condition has to last or expected to last at least a year. And presumably, if you were able to perform the duties of your job prior to becoming pregnant and coming off of your medication, then, once you're able to, or once you have the baby, then you'll be able to resume medication. And again, a year has not elapsed at that point. So I think that the best option at that point would be to look into short-term disability options. The next question asks, while awaiting diagnosis, would someone qualify for FMLA? So let me qualify my response here. This may be a question that you want to ask in the accommodations session, but I will tell you, since employment law is not my area of expertise, FMLA is not necessarily available to everyone. It depends on the size of the business, how many employees are employed by the business. So if FMLA is available to you through your employer and you have some support from your physician, then I think that you should be able to utilize your FMLA to try to seek proper treatment or more effective treatment. The next question asks, and this is a great question here that I get often, I've quit my job due to symptoms of narcolepsy. Will applying for unemployment remove eligibility for SSI or DIB for 5 months? So this question actually encompasses a few questions. The first is, what is the impact of applying for unemployment or receiving unemployment benefits and also applying for Social Security disability, whether that's SSI or SSDIB or both. And the impact of that is it depends. It depends on your age. Generally speaking, when you're applying for unemployment, what you are asserting is that I am available to work, I am ready to work, I'm able to work, I just need to find a job. And that is contradictory, at least if you are a younger individual, younger being under the age of 50, that contradicts with what you are asserting when you apply for Social Security disability, which is that I am unable to work because of my conditions. My conditions keep me from working and I need some benefits. So it does not preclude you from applying from Social Security disability benefits if you are receiving unemployment, but it can complicate the receipt of those benefits. Also, if you're receiving benefits from the state, and of course this is going to depend on what state you live in and what the state rules are, but I would say that in many, if not most cases, the receipt of unemployment benefits and any overlapping disability benefits could or should create an obligation for you to repay the state for those unemployment benefits. So it's entirely possible for you to receive unemployment while applying for disability, but ultimately there could be some difficulties with the two statements. There could be some clashing there with the two statements. And what I would recommend is that you consult with an attorney if you are planning on applying for disability from Social Security about the implications of the receipt of unemployment benefits as well, particularly if you are under the age of 50, because the rules are different for those individuals under the age of 50 than they are for those that are 50 plus. The next question, which is also one that I get frequently, is it possible to have partial disability to supplement income so I can go from full-time to part-time? Working less would improve my quality of life immensely. Now, unfortunately, Social Security disability does not have a partial disability program. It is an all or nothing program in that if you are able to work part-time, depending on how much money you make, working part-time, that may preclude you from being eligible for Social Security disability benefits. So again, it's one of those situations where it really depends on what you're doing work-wise, how many hours a week you're working, and how much you're being paid. Your best course of action would be to go over the specific details of your situation with an attorney who could advise you as to whether or not you would even qualify for disability. It is certainly possible, and there are many individuals who receive Social Security disability benefits that are able to work part-time, but there are some rules and regulations that have to be satisfied in order for that part-time work not to interfere with the receipt of Social Security disability benefits. And again, an attorney can walk you through that process and explain to you how it would impact you. Another question is, do you need to have an attorney if you go for a hearing? And I would say yes. It is not a requirement that you have an attorney, but you do not want to walk into any legal proceeding and not be represented by an attorney that specializes in understanding the rules and regulations as it pertains to that particular area of law. So no, I would not go to a hearing without an attorney to represent me. You need to understand what you're walking into and understand how Social Security's rules apply to you before presenting your case to a judge. With that being said, it is optional for you. You don't have to, but I would not advise it. I would not recommend it. Another question is it better to apply online or in person? Right now, because of COVID-19 and the pandemic, the Social Security hearing offices, or excuse me, local offices, field offices where you would go to traditionally file an application, have switched over to trying to do things online. I do believe that you can make appointments in some offices, but it is perfectly fine to complete your application online, and you will get a confirmation once you've completed that application to let you know that yes, you've submitted everything that you need to submit in order to get the application process started. If this were not a situation with COVID-19 and the world was as we once knew it, either way, it's just a matter of personal preference as far as applying online versus in person. It can be beneficial if you're not familiar with, or you have some difficulty getting through the questions. It can be helpful to have someone else kind of guide you or walk you through it. You also have the option of, filling out, either filling out the application online, calling and talking with Social Security, and they will walk you through the process over the phone to get the information that they need. The next question is, I work full-time and frequently have appointments. I use intermittent FMLA for some missed work. Am I able to apply for disability for medical insurance while working? My appointment co-pays are very expensive. So if you're working full-time, and even though you're using your intermittent FMLA, you're not going to meet Social Security's definition of disability. And remember, with that, you're saying that the condition has lasted or is expected to last at least a year or more, and it's keeping you from engaging in this full-time activity, which is also known as substantial gainful activity. So as far as your eligibility for Social Security disability is concerned, under those circumstances, you would not be eligible at this time. And I think I've got time for one or two more questions here. The next one is, if I am on Social Security disability, how many hours may I work in a part-time job without losing the Social Security disability income? And the answer to that is it depends. It depends on a couple of factors. One is, is that part-time work, are you working as many hours as you're able to manage? If the answer to that is yes, the next question is, how much money are you making? And Social Security has some rules about how much money you can make and continue to receive disability benefits. It also depends on, are you receiving benefits from SSI, or are you receiving benefits from SSDIB, which is the workers program? Now, I would be happy to explain in greater detail to the person who asked the question their specific situation and go over the calculations with you individually. Feel free to send me an email or give me a call, and I'll be happy to do that with you. I did want to get in one more question. I am currently using intermittent FMLA. If I run out of paid time off, is it possible to work part-time and use short-term disability part-time? And the answer to that is I would consult with an employment attorney and go over the specific details there. You also want to get information from your HR about the short-term disability benefits program. There may be some more details provided there which could answer that question for you. And I believe that we have covered all of the questions that I have received. So thank you all very much for tuning in and asking great questions. As I stated, if you have any additional questions, please feel free to reach out to me via email or via telephone, and I will be happy to discuss the circumstances with you individually. Thank you so much.